Oh, you didn't think the Young Thug trial was done, were you? Oh no. The lawyers are smelling blood in the water. Attorney Brian Steele senses weakness, and he's going for the throat. Attorney Steele files a proffer that is ruthless. Absolutely ruthless. And I am here for it. Welcome to the show, folks. All right, let's go through it. In the Superior Court of Fulton County, State of Georgia, v. Jeffrey Williams, notice of attorney proffer after being prohibited from cross-examination and presenting a full critical defense at trial. You don't see these words often in a proffer, but here we are. Comes now Mr. Jeffrey Williams by and through undersigned counsel, and hereby files this notice of attorney proffer after being prohibited from cross-examination and presenting a full critical defense at trial in the above reference case. In support of this notice of attorney proffer, Mr. Williams' undersigned counsel show as follows. Background and attorney proffer. On Tuesday, May 14th, 2024. Now, you might ask yourself, but that's a bit long ago. Yeah, because the judge disqualification thingy, that will only roll back the trial to June 12th. The lawyers now are looking, okay, what other timestamps do we have in this trial so we can roll back even more? And Mr. Steele shows Tuesday, May 14th, 2024. During the direct examination of Agent Racy, Lawyer Hilton, representing the state of Georgia on behalf of Fulton County District Attorney's Office, played over confrontation clause and hearsay objection on October 22nd, 2015 at 9:33 p.m. recorded jail call of Mr. Jimmy Winfrey and a person known only as Rashad. During this October recorded telephone call, Rashad explained that he heard from another unknown person that a Porsche vehicle as well as $250,000 was waiting to be given to Mr. Winfrey once he finishes serving time in custody. The prosecution theorized that this vehicle and money were rewarded for Mr. Winfrey's silence. Okay. Not to speak with law enforcement about who, if anyone, was supposedly the person or persons responsible for the April 26, 2015 Ford bus shooting and other gang-related crimes. See that link? It's not to me. Sadly, it is probably to the law and crime thingy. To date, and based upon information and belief, Rashad, the other unidentified unknown person as well as Mr. Winfrey, have not and will not testify at trial. Undersigned counsel does not know the identity of Rashad or the unidentified person and therefore cannot locate, interview, or call any of these persons as witness. Mr. Winfrey is a severed, in custody, co-defendant and, based upon information and belief, has and or will exercise his constitutional right to remain silent. After playing this above reference recording for the petite jury, admitted into evidence as State's Exhibit blah blah, the prosecutor questioned witness Agent Racy and elicited that within approximately a month of this recorded jail call, Mr. Winfrey pled guilty to indicted charges in Cobb County. The prosecutor's clear import of this testimony is to persuade Mr. Williams' jury that shortly after being promised this vehicle and money, Mr. Winfrey accepted responsibility for this crime in order to show loyalty to the supposed gang. Thus, Mr. Winfrey did not fight his then pending Cobb County indictment by proceeding to trial, and instead sat mute in prison because he sacrificed himself for the betterment of the supposed YSL gang by entering this guilty plea. On Tuesday, May 14th, 2024, lawyer Hilton and everyone connected with this case knew or had a duty to know that Mr. Winfrey's guilty plea entered after his recorded jail conversation was deemed involuntarily tendered, was withdrawn as the Cobb County Trial Court, specifically Cobb County Superior Court Judge Staley, was found to have coerced Mr. Winfrey to enter this guilty plea involuntarily. Thus, the involuntary guilty plea was not knowingly, freely, intelligently, and voluntarily entered. There are a lot of exhibits in this. And I remember this. At that time, I said, this is ridiculous. Nobody, first of all, overhears a confrontation because they can cross-examine. And something you will find out now, that guilty plea was overturned. What happens with the guilty plea when it is overturned? Folks, you know this. It is non-existent anymore. And still, the judge allowed it in as evidence. That is clearly a mistrial question. A question for mistrial. In reality, the above reference recorded jail call had no impact on Mr. Winfrey's decision to plead guilty, as the truth is that Mr. Winfrey was desirous to go to trial. In fact, on the date of the tendering of this involuntary guilty plea, Mr. Winfrey maintained innocence and intended to exercise his constitutional right to a jury trial until that trial court coerced him into enter this involuntary plea. Based upon the above, the prosecution has manipulated facts and put forth knowing false information before the jury. Undersigned counsel immediately objected to this questioning by lawyer Hilton and responses of Agent Racy at the bench conference, told the court that it was wholly shocking, untruthful, and misconduct for the prosecution to knowingly use a coerced involuntary guilty plea against Mr. William at trial. The court denied undersigned counsel request for any relief or admonition to the jury to ignore, exclude, and remove any testimony regarding this month later guilty plea. Further, the court ordered undersigned counsel not to cross-examine Agent Racy on this false and misleading topic, wrongly introduced by lawyer Hilton. Later in the trial day, on Tuesday, May 14th, undersigned counsel made an attorney proffer concerning his desired cross-examination of Agent Racy, since the court ordered undersigned counsel not to cross-examine Agent Racy on the topic of this coerced involuntary guilty plea. The Supreme Court's opinion in Winfrey v. State, Supra, the fact that Mr. Winfrey wanted a jury trial, that lawyer Hilton's use of this coerced guilty plea was misleading and introduced knowing impermissible testimony, and that there was Cobb County judicial misconduct that birthed Mr. Winfrey's involuntary guilty plea in 2015. Because of the court's order, undersigned counsel forfeited his cross-examination of Agent Racy regarding the accuracy and completeness of his testimony, and undersigned counsel was prevented from correcting the prosecution's intentional use of the coerced, withdrawn, vacated, involuntary guilty plea. Undersigned counsel intended to cross-examine Agent Racy to challenge his above referenced trial testimony and use the transcript of the Cobb County November 20th, 2015 involuntary guilty plea. Exhibits late. I will not show all the exhibits because then we will be here until tomorrow. As I said, Brian Steele, there's blood in the water, and he's not pulling any punches here. Admit a copy of the opinion in Winfrey v. State, Supra, whereby our highest court held that the guilty plea was not voluntary. Further, undersigned counsel intended to call the 2015 trial lawyers for Mr. Winfrey in the Cobb County indictment, specifically the Honorable Lawrence Zimmerman, Esquire, as well as the Honorable Manubir Mani Arora, Esquire, to explain the conduct leading to the entry of the above involuntary and coerced guilty plea and their observations during this coerced guilty plea. Also, undersigned counsel intended to call Mr. Winfrey's appellate lawyer in Winfrey v. State, Supra, the Honorable Steve N.Starow, Esquire, to testify about this coerced guilty plea as well as the August 7th, 2020 Alford plea, wherein Mr. Winfrey maintained complete innocence and only entered an Alford plea because he received a time-served sentence. See, I will probably link to it. Yeah. Certified copy, blah, 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 blah. All of the above would permit the jury to intelligently consider whether the October 2015 vehicle money recorded jail call had any impact on Mr. Winfrey to forfeit his right to a trial and or silence Mr. Winfrey not to cooperate against Mr. Williams or others. This truthful evidence would also unmask the prosecution's team's use of untruthful testimony. Instead, undersigned counsel has been denied Mr. Williams' right to defend this case, introduce evidence, confront witnesses, have a fair trial and right to due process. Mr. Williams has been denied his constitutional right to present his defense, has been denied his constitutional right to cross-examine on this relevant material issue introduced at trial by lawyer Hilton, has been denied his constitutional right to a fair trial, his constitutional right to correct the testimony, his constitutional right to introduce highly probative evidence and call witnesses at trial, his due process rights, all under the below provisions of the United States Constitution and Georgia Constitution. And then they go into case law. Sixth Amendment. The Sixth Amendment guarantees criminal defendants meaningful opportunity to present a complete defense. Quote. End quote. This attorney proffer is made to ensure that these topics are properly preserved. A mistrial should have been, and should be declared based upon this court's ruling that denied Mr. Williams' constitutional right to cross-examine, his constitutional right to present a defense, his constitutional right to call witnesses, his constitutional right to a fair trial, and his constitutional right to due process. This attorney proffer continues. On Friday, June 7, 2024, witness Copeland asserted the Fifth Amendment in front of the jury. That should never have occurred as, based upon information and belief, the prosecution team, as well as this court, knew that witness Copeland was going to do same before Mr. Copeland was called to testify in front of the jury. Before same occurred, undersigned counsel did not know that it was Mr. Copeland's intent to refuse to answer questions in front of the jury. Once Mr. Copeland invoked his constitutional provision, undersigned counsel immediately moved for a mistrial, which was denied. The court then denied Mr. Williams' counsel's request to call witnesses to prove that the prosecution team knew that Mr. Copeland intended to invoke the Fifth Amendment in front of the jury if/when he was called to testify by the prosecution. Undersigned counsel decided to call Fulton County District Attorney Investigator Lang and Lieutenant Lancy Cott, who is also employed by the Fulton County District Attorney's Office, to memorialize their knowledge that Mr. Copeland expressed that he would invoke the Fifth Amendment in front of the jury. Moreover, undersigned counsel intended to call reporter George Sheedy to testify that he was ordered immediately prior to Mr. Copeland taking the witness stand and refusing to testify not to video Mr. Copeland if/when the court ordered him to be arrested for refusing to testify. Based upon information and belief, reporter Sheedy was given this edict by the Fulton County Sheriff's Office deputies based upon an order of this court. If true, this court had knowledge that Mr. Copeland would likely refuse to testify in front of the jury once called as a witness. And Exhibit D is an article by reporter George Sheedy. From whom did the court receive this information? Why did the court not reveal the same to undersigned counsel before permitting Mr. Copeland to testify before the jury? Attorney David Botts announced in open court that before Mr. Copeland took the witness stand, Mr. Copeland uttered, in close proximity to members of the prosecution team, that he would go to jail and would refuse to testify before being called as a witness before the jury. When Attorney Botts announced this proffer to the court, this court stated that it had a problem with Attorney Botts. The blame belongs on the state for calling Mr. Copeland, knowing or having reason to believe that he would refuse to testify in front of the jury. The same blame is attributed to the court if it knew the same information before Mr. Copeland testified before the jury. Mr. Williams and his counsel were in the dark about Mr. Copeland making it clear that he would refuse to testify in front of the jury. This court did not permit undersigned counsel to call any witnesses to support his timely voiced motion for mistrial. Hence, this proffer is hereby in place. Moreover, oh wait, there's more. On April 29th, 2024, during the cross-examination of Detective Gator by the Honorable Maxwell Short, Esquire, counsel for Mr. Stilwell, Detective Gator improperly injected her quote-unquote expert opinion that the criminal street gang YSL committed a shooting of another person. Immediately, undersigned counsel objected and asked for a mistrial, and at the bench conference, this court found that the demeanor of Maxwell Short, Esquire, goaded Detective Gator into giving this in unsolicited prejudicial testimony in front of the jury. As proven in the trial audio, Attorney Short never goaded this improper prejudicial testimony by Detective Gator, and therefore the court's observations to perfect the record are hereby challenged. Wherefore, this attorney proffer is made to correct and supplement the record this first day of July 2024. By Brian Steele, Keith Adams. So there is where we are now. And I can almost guarantee this is not the only attorney proffer that is about to be filed. But it is the one we have to look at today. Thank you for listening. I'm going to keep an eye on this. You know I will. I've been covering this case for over a year now. Yeah, this isn't done. Not by a long shot. I'm not done. The attorneys are not done. The only person that should know they're done is Judge Glanville. Judge Glanville, you're done. Thank you for showing up. Until next time, like, subscribe. You know all the YouTube things. And I will see you later in the next video or in the next stream. Bye-bye.